Hey guys, let's talk about legal issues in nursing. The nurse is always accountable for the outcomes of his or her actions while carrying out nursing duties. And this includes every single piece of nursing, like assessing, planning care, providing care, medications, communication, delegation, knowing when to call the MD, critical thinking through all potential patient outcomes, and when you need to take further interventions, patient advocacy, discharge planning, and much more. Now, y'all all know that I love Florence Nightingale, and this is a pretty cool quote that she had. It may seem a strange principle to enunciate as the very first requirement in a hospital that it should do the sick no harm. She was quite brilliant. Alright, so the term law and statute basically mean the same thing. Statutory laws are the most common laws that we see and know. Conflicts in law always go with the higher level of the law when you have a conflict. Federal law supersedes the state law's conflict, and state law supersedes local law. Nurses must fully understand laws related to patient safety, professional practice, laws affecting their specific nursing area like EMTALA, and with the healthcare system. Ignorance of the law is never a defense. Nurses can be subject to penalties, fines, suspicion, and revocation of their license, or even jail time. All healthcare facilities that obtain funding from Medicare and Medicaid must obey these rules. A federal violation can lead to Medicare and Medicaid revoking funding, and this is very significant. The Center for Medicare and Medicaid Services has the authority to establish new rules and regulations to enhance patient safety and quality and reduce the cost of care. Examples include never events like foreign object retained after surgery, air embolism, blood transfusion error, stage 3 or 4 pressure ulcer development, trauma resulting from a fall in a healthcare facility, poor blood sugar control, a urinary tract infection after Foley placement, surgical site infections, DVTs and PEs, and there's much more. Some types of federal statutes that we're going to discuss in more detail are the EMTALA Law of 1986, Americans with Disabilities Act of 1990, Patient Self-Determination Act of 1990, and Health Insurance Portability Accountability Act, or as we well know it, HIPAA of 1996. So emergency medical treatment and active labor law, EMTALA. This is basically the anti-dumping law. It prohibits the refusal of care for indigent and uninsured patients seeking medical assistance in the emergency department, and the transfer of unstable patients, including women in labor, from one facility to another. Facilities can be fined $50,000, and the federal government can revoke the facility's Medicare funding. An advocate for patients and be aware of EMTALA is being violated is what the nurse's role is. It's not a violation of EMTALA if it is a planned surgery. So private practice denying a knee replacement to a patient who's unable to pay. The Americans with Disabilities Act of 1990. A healthcare facility must provide reasonable accommodations to patients and their families. Can be black and white or a gray area in many situations. Nurses must advocate for patients and be sure they have a clear understanding of the patient's treatment plan. Assure informed consent. Promote autonomy and decision making by providing reasonable accommodations. An example is voice box amplifier, using sign language interpreter, or even Braille. The Patient Self-Determination Act of 1990. Patients' rights were under this act include participating in their healthcare decisions, accept or refusal of medical treatment, and making advanced healthcare directives like the DNR status, living will, or durable power of attorney. The nurse should be the advocate and educate the patient, and this is often done by the nurse during an admission to the hospital. And show this, we need to make sure that we educate our patients and not judge. So the Health Insurance Portability and Accountability Act of 1996, or HIPAA as we know it, ensures confidentiality of the patient's health information. Title I protects the health insurance coverage for workers and their families when they change or lose their jobs. Title II is the privacy rule. It addresses the security and privacy of health data information, and that's what we most know HIPAA as. It establishes regulations for the use and disclosure of protected health information. And protected health information is any information held by a covered entity which concerns health status, provision of health care, or payment for health care that can be linked to an individual. This is interpreted rather broadly and includes any part of an individual's medical record or payment history. Example of HIPAA violations: showing colleague pictures of a patient's leg and discussing them just for the sake of discussion and not related to the patient's healthcare needs or education. Accessing your own medical record, or looking at other patients' hospital records when not caring for them. State Nursing Practice Act and Board of Nursing Rules and Regulations. The history: in 1938, New York State passed the first Nurse Practice Act. By 1952, all states had Nurse Practice Acts. Wisconsin's was in 1911. Each state has its own practice act. The WNPA is the statute that defines and controls nursing practice in Wisconsin. It's administered and enforced through the State Board of Nursing. The state legislators pass statutes that define and regulate the practice of nursing, and defining the scope and limitations of professional nursing practice in order to protect the public and make the registered nurse accountable for his or her practice. The NPA is a law, and that's very important for you to remember. And the NPA have the same force and effect as any other law, and not knowing the NPA causes many nurses to violate the law. So be familiar with the NPA in the state that you work in. If you are not going to be in Wisconsin, make sure you know theirs. Nurse-patient ratios and mandatory overtime statutes. In California, a unionized healthcare system established a minimum ratio in acute care healthcare facilities. Wisconsin does not have any rules or regulations regarding this, however. Reporting statutes mandates reporting of specific health problems and the suspected or confirmed abuse of vulnerable individuals in society. It's reportable in all states, including infant and child abuse, dependent elder abuse, and communicable diseases like TB, syphilis, and H1N1. Institutional licensing laws. All healthcare facilities and their employees must meet minimal expectations. Like for registered nurses, it's education, experience, and credentialing. Registered nurses must ensure that they're meeting these requirements because the growing trend is to hire managers and supervisors who have no healthcare experience and don't understand registered nurse requirements. An example is in fire safety, bloodborne pathogens, and chemical safety, which is called the hazard triangle. So make sure that you go in and read the entire definition of a registered nurse per the Board of Nursing in your textbook. And although NPA in each state may look a little different, they will all contain similar information. So N1 is program approval for schools of nursing. N2 is licensure, qualifications for licensure, application and procedure for applicants from board-approved schools, and temporary permits. N3 is examining councils. N4 is licensure of nurse midwives. N5 is renewal of license. N6 is standards of competent performance with a focus on assessment, planning, intervention, evaluation, performing delegated medial acts, and supervision and direction of delegated nursing acts. N7 is rules of conduct with a focus on grounds for denying renewal or disciplinary action, non-compliance with federal jurisdictional or reporting requirements, violating or aiding and abetting a violation of any law substantially related to the practice of nursing, or being convicted of any crime substantially related to the practice of nursing, confidentiality, patient privacy, consent or disclosure violations, misconduct or abuse, fraud, deception, or misrepresentation, and improper supervision or allowing unlicensed practice. And 8 is certification of advanced practice nurse prescribers, and 9 is nurse licensure compact. So violations of the NPA can occur easily if a registered nurse is not familiar with the statutes. The State Board of Nursing determines if a registered nurse has failed to comply with the NPA, and if guilty, the nurse can be issued a formal reprimand, be placed on probation, be fined, or have limits, suspension, or their RN license revoked. So this shows you the grounds for disciplinary action. I'll just let you read those on your own. All right, so review the N2 licensure by exam. Per the NPA, it's illegal to sign RN until you have passed the NCLEX exam, and your license can be revoked by the state if it deems that it's necessary. Your temporary permit is talked about in N2 subchapter temporary permits. A nurse who has graduated from a board-approved school but is not licensed yet may be granted a temporary permit to practice until the nurse can qualify for licensure. To maintain eligibility for this, an applicant shall schedule and take the exam prior to the expiration date on the temporary permit. The holder of a temporary permit shall practice only under the direct supervision of a registered nurse. They may use the title of GN as graduate nurse, but not RN as registered nurse. The duration of the temporary permit is usually for 3 months, or until the holder receives a failing exam result, whichever is shorter. Practice under temporary permits, including renews, may not exceed 6 months total duration. And the temporary permit can be renewed once by completing an application, completing a nursing workforce survey, and payment of application fees. Protect your license. That is of utmost importance for you. License renewal is now completed online, and your RN license will be sent to you via email or mailed to your address. Renewal is currently every other year and is normally due by the end of February. If you do not renew before your license has expired, you are not able to work as a registered nurse. If not reviewed for 5 years, you may have to prove appropriate knowledge to have that renewed again. Many times registered nurses don't practice within their scope due to physician demands. An example of that is it's okay to write orders without calling the MD at night for things like Tylenol, milk of magnesia, Mylanta, stuff like that. So really know what you're doing, protect your license. All right, let's talk about common law. Nursing practice is also guided by common law. This is the body of principles that evolves from court decisions. It's referred to as common law or decisional law. Common law is continually being adapted and expanded. Example, affirmative duty, which is the duty to prevent harm. If you are working a night shift and your patient experiences chest pain, an EKG is obtained per the order and cardiac enzymes are drawn. When receiving the labs, you note that the serial enzymes have dramatically increased, but you fail to notice the provider. The patient has a heart attack because you failed to notify them. If the physician were notified, the patient could have been taken emergently to cath lab to revascularize the dying heart. Also with an example for patient abandonment. There's no statutory law regarding patient abandonment. No law dictates that a registered nurse cannot leave a seriously ill patient without ensuring another registered nurse will provide care, but common practice and customs requires that registered nurses do not abandon their patients. This would be supported by other expert registered nurses as well. Failure to meet the standard might be deemed a violation of common law. All right, now let's talk about civil law. Tort law is the wrong results from a breach in one's legal duty regarding interpersonal relationships between private persons. Suits are brought on by one person against another and are based on the concept of fault. Representation. The person who initiates the civil law, the plaintiff, seeks damages for the wrongful behavior from the offending person who is the defendant. Lawyers are involved in presenting this case. Final judgment. Damages are generally awarded in form of money to compensate for damages. This can include reimbursement, loss of wages, rehabilitation services, or money for pain and suffering. Torts are either intentional or unintentional. Unintentional tort is an unintended wrong against a person. Intentional tort is a willful act that violates another person's rights or property. A tort can be the denial of a person's legal right, the failure to comply with a public duty, or the failure to perform a private duty that results in harm to another. Intentional tort, the nurse intends to perform the offensive act. Legal ramifications in all of these cases, the registered nurse may face fines and punitive damages, restriction or loss of the registered nurse license, and if criminal, they can face jail time. An example is a breach of patient confidentiality, like especially with HIV patients and psych patients. Assault is causing the person to fear that he or she will be touched without consent. Battery is the unauthorized or actual harmful or offensive touching of a person. Actual harm may or may not occur as a result of assault and battery. Self-determination and autonomy. Patients have the right to refuse treatment even if that treatment would be in their best interest. And the registered nurse must always communicate with the patient when touching the patient or performing any procedures so that it's not considered an inappropriate touch. Informed consent is required in the healthcare environment as a defense to battery. Here's an example of assault. An RN threatening to place a tube feeding if the patient does not eat enough food or take his or her medications. An example of battery is actually placing the tube feeding. And then an example of what would not be considered assault and battery, the RN's threatening to place an NG to give a patient activated charcoal if he or she does not drink it. Or the RN is placing the NG tube to save the patient's life. Now, informed consent is defense against battery. Like I said previously, consumers of healthcare need a great deal of information and should be told everything that they would consider significant in making a treatment decision. The role of the nurse in informed consent is to collaborate with the physician. The nurse may witness a patient signing of informed consent documents, but is not responsible for explaining the proposed treatment or evaluating whether the physician has fully explained the risks, benefits, and alternatives. The nurse's primary responsibility is to determine that the elements for valid consent are in place, providing feedback if the patient wishes to change consent, and communicating the patient's need for further information by the primary provider. If you are unable to find documentation of proof of informed consent, the patient should not sign a consent form. The best way, if you are unsure, is to ask the patient. Did the physician talk with them? What do they know of the risks and benefits? Has this been explained to the patient and family? Look in the MD's history and physical or progress note to see if it's typed in there. Talk to the physician themselves or actually witness the discussion. So types of civil law intentional tort. One is libel, an injury to one's reputation caused by written word. Examples are labeling a patient as a drug seeker. So be careful when you're charting patient complains instead of, you should write patient states, because that's a negative view otherwise. Another type is slander, which is an injury to one's reputation caused by spoken word. Slander is often overheard by family when registered nurses are speaking to each other. And oftentimes, the nurse can damage a patient's reputation by speaking about somebody being lazy or non-compliant. And be careful when speaking about a patient. You must use only objective and professional language. Avoid this by steering clear of gossip and or writing negative documents about others in the heat of the moment. You have to make sure that you are being objective. Patients have the right to self-determination and can refuse care if mentally competent or do not face a danger to another. An example is a patient may leave against medical advice but needs to be aware of the risks in doing so, and the provider or supervisor must be made aware of that as well. Against medical advice paperwork needs to be signed by that person before they leave. An example of when restraints are not okay: if you don't stay in bed, I'll have to sedate you. Or you restrain a patient who is continually pulling out a tube feeding. There are times when a patient must be restrained. If they are posing a harm to themselves due to confusion or sedation, such as an ICU patient that's often restrained, but there's strict guidelines that have to be followed because of that. And if they're a harm to others, like an intoxicated emergency department patient or in a mental health setting. The goal of restraints is to use the least restrictive restraint, and only when all other strategies to ensure patient safety have been exhausted. An invasion of privacy occurs when a patient's private affairs and medical cares is made public without consent. Their electronic medical record can do this. Be careful not to share your passwords, as others may access patient information and break confidentiality, and it's going to look like you did that. A breach of confidentiality would include assessing patient records of patients you are not caring for. A breach is also assessing your own medical records without consent or privilege to do so. In the Code of Ethics, it says the nurse has a duty to maintain confidentiality of all patient information. The Health Insurance Portability and Accountability Act of 1996 was the first ever federal privacy standard governing protection of patients' medical records. There are two types of unintentional tort: negligence and malpractice. Unintentional torts are harm to a person either physically, emotionally, or economically that they may occur without any intent. A negligence example: if you live in the country and decide to burn your garbage on a windy day. Halfway through the burning the garbage, you see that sparks are going into the nearby woods. As a result, you start a small fire in your neighbor's woods and cause damage to his deer stand. This would be considered negligence because any normal person would know that burning on a windy day would have a negative result. And then testimony is not required because the actions are so careless a lay person would be able to recognize the conduct as negligent. So types of negligence: you have gross negligence. The registered nurse is so reckless and reflects a conscious disregard for the patient's welfare. These patients often do not die but can suffer because of the nurse's actions. The jury result: the plaintiff is often awarded punitive damages. So an example of that is when a patient receives a pacemaker and the registered nurse chooses to not properly assess the site or change the dressing. The site becomes infected and the pacemaker later needs to be removed. There's also criminal negligence, when the conduct is deemed so reckless that the action results in serious harm or death to a patient. The jury result may include loss of job, disciplinary action by the State Board of Licensing, fines, or possible revocation of the healthcare organization's Medicare and Medicaid funding. An example is when you do a TPN at 1,000 mLs per hour and the patient dies. So this is some research on negligence. It's pretty amazing to see what percentages are where these occur. In the acute care setting, it's 61%. Long-term care setting, 18%. Advanced practice nurses are 9%. Psychiatric setting is 8%. Physicians, 2%. And home care agencies is 2%. So malpractice is a type of negligence. All involved can be taken to court or be sued. An example is you caring for a patient who's in acute heart failure. The resident that you're working with writes orders for 200 milligrams of lisinopril. The normal dose is 20 to 40 milligrams. When reviewing the orders written, you question the order to yourself, but never address the unusual dose with the physician. When the medication arrives from the pharmacy, you give it to the patient. Later, the patient suffers from extreme hypotension, and despite all attempts to save her, she dies. This is an example of a malpractice because the registered nurse should have known that this is too high of a dose for lisinopril. the nurse, pharmacist, and physician could face possible malpractice suit because of their training, and they should have known better. Another example is the MD in an ER did not order a CAT scan of the head of a patient after they fell because he did not feel it was indicated. Unfortunately, the patient was discharged and later came back with a brain injury after the provider did a lot more head scans, and some were done in patients who probably did not even need them because of this lawsuit that happened to him. So malpractice in court, an expert witness is required to establish whether the person breached the expected standard of care. These are just a few factors that can increase your chances of malpractice suit, but I'd like you to take a few minutes to review. I'm going to take a few minutes to review them in more detail. Nursing shortage is often the result of sick calls or FMLA. So failure to communicate, like failing to call the physician. Your patient has runs of VTAC or abnormal lab values and you don't call. Always listen to your patient and seek to understand what it is they need or why they're upset, and try to remediate the problem before it grows. Research shows that registered nurses and physicians that develop a trusting relationship with their patients are much less likely to be sued. If you're not getting the answers you want or orders that you need, always continue to seek further medical help for that. You may need to get the hospital supervisor involved, page another physician, or some type of process. This may be the case if you page a physician and they do not call you back. And then failure to delegate. You'll always know the skill level and educational level of the person you are delegating to, and we learned that back in our delegation learning plan. An example is when the CNA was asked to take a blood sugar and then treat the low blood sugar while the registered nurse went on a cigarette break. Now that is definitely not correct. So failure to follow standards. An example is in an operating room when the nurse failed to follow well-established hospital policy for identifying and preparing patients for surgery. This breach in procedure resulted in the removal of one patient's only functioning kidney. The physicians and facilities were also involved in this case, but the nurse was co-defendant because she fell below the standard of care. And if the standards were followed, serious injury would not have occurred. Another example is giving Tylenol if it's not ordered and then getting the order in the morning. Nurses are responsible to question orders that are inappropriate. Things are always changing in healthcare. Be sure to attend your yearly competencies, all in services that are provided, and if you don't understand something, you must ask. Always be sure to use equipment the way you were taught. An example is new IV pumps, cardiac monitors, PCA pumps, or lift type equipment. Infections due to improper dressing changes are an issue, and just one of the problems that can result from that. Always remember, if it was not charted, it was not done. I don't care if you did it. If you did not chart it, it was not done. You cannot go to a court proceeding and say, well, I did that, but there's no documentation. Nobody's going to believe you. If you did communicate your concerns with no response, you must document that and use the flat mnemonic. F is for factual, L is for legible, A is for accurate, and T is for timely. Failure to reassess if there is a change in condition is also a contributing factor to malpractice suits. An example is if a patient falls, the registered nurse should be continually reassessing the patient's vital signs, length of level of consciousness, cognition, or any complaints of injury, and then update the physician and family if there are any changes. And this can take you back to the video in the delegation learning plan of when that didn't occur. So my goodness, when's the last time anyone checked on Mr. Klink in room 207? Looks like quite a while. All right, Continuing with contributing factors in malpractice suits, failure to act as a patient advocate. Assessing a patient's home plans or support services, we always need to ensure that we send patients home to safe environments. And providers do not always review pertinent data, so be sure to update the physician as the nurse in that situation with things like labs and vital signs and patients' weights. And then advocate for the treatment plan or notify the physician if he or she is unaware of the current status and it's not reflected in the treatment plan. And an example of this is a patient who was admitted with SBO but not placed on Ritalin. Ask about starting this treatment. Advocate for physical therapy and occupational therapy as appropriate. So the RN owed the client a duty of care. When you accept a patient assignment, it's your duty to possess the knowledge and skill to care for this patient. You are accountable for your practice even if you are picking up extra. That does not matter. Be careful with this when you are floating and are unfamiliar with the patient or the treatment plan. And this includes telehealth. Also, the RN breached this duty when evidence is present that proves the RN breached the standard of care. The standard of care is what the nurse expert witness states it is, and nurse experts often are another nurse, a nurse supervisor, nursing faculty, or a dean of nursing. There's a connection between the breach and the standard of care by the registered nurse and the patient's injury. There is no other cause found for what happened to the patient. A direct cause and effect can be found. Know the standards of care you will be held to. That is very important. An example is when a patient was admitted with syncope and recent weakness. The prior registered nurse reports that the patient has been having syncopal episodes while the patient tries to go to the bathroom. Later in the shift, the patient states she has to have a bowel movement. The registered nurse helps the patient into the bathroom but leaves her there alone. After the registered nurse leaves the patient, they have another syncopal episode, falls, and breaks their hip. In this situation, the registered nurse could be found negligent. Let's talk about the Good Samaritan law. In Wisconsin, we have a law, duty to rescue. Within this law, all persons are required to notify law enforcement or seek aid for strangers in distress. As nurses, we must act in accordance with the training we have received. So an example of this is if a person falls off a ladder, we know that the person should lie as still as possible until medics are able to stabilize his spine. We would be in violation of our training if we encourage the patient to get up and move around. So standards of care. What is the standard of care? Where can you find the standard of care? As nurses, you must report professional misconduct. How do you keep your nursing skills up to date? You can use annual skill fairs, annual competencies, mandatory mania, Complete Star, professional journals, professional conferences, in-services, and the classes that you can find. So nursing standards of care. There are ways that you can stay current through policies and procedures, nurse educators, organizational educational seminars, conferences, nursing journals, annual skill fairs, amongst another bunch more. How do you reduce your risk? Maintain an open, honest, and respectful relationship with your patients, the staff, and other providers. Maintain an open communication with patients, staff, and providers. Maintain competence. Know your legal principles. Practice within your licensure, and know your strengths and weaknesses. So reduce your risk. Let's talk about incident reports. When to create an incident report. Patient's injury, unanticipated patient death, malfunction or failure of equipment, inability to meet the patient needs, unethical, illegal, or incompetent practice, patient complaining regarding a healthcare provider, violent behaviors from patients or families. Nurses are legally bound to report critical incidents to their nurse managers, administration, and risk manager via an incident report. And some facilities have different names for them. When you complete the incident report, make sure that you describe all events objectively, avoid opinions. Be sure to include the provider's response. If there's no orders are received, write that. And do not note the report in the chart. You're technically trying to hide it from the lawyers. So risk manager, a person in a healthcare agency will employ to track the accidents and injuries, establish and strengthen to reduce preventable patient injuries or death, eliminate the loss of revenue related to incidents that occur, and they're knowledgeable about state and federal laws. And from incident reports, the agency is able to assess patient safety and quality. They're used to better the organization and the nurses. They're used for quality improvement processes. They look at practice trends, educational needs, and equipment problems. Personal liability. You will be held accountable for the cares that you're given and not given, and the outcomes that arise because of this. Even if you're picking up an extra shift, it does not matter. Nurses assume responsibility for patient harm or injury that's in the result of his or her negligent actions. Physicians and independents are captains of the ship, and that's no longer true. Nurses can be liable for delegated tasks and for their own standards of care. As an example, if a patient's admitted with syncope and they fall when on the toilet because the CNA or you as the nurse did not stay with the patient, you as the nurse are liable. You can be held liable for the actions of the CNA if proper communication and delegation was not completed. There's a misconception that the RN will be protected by the health insurance agency, the healthcare agency, if the registered nurse is working outside of the policies or procedures. The healthcare organization will not stand behind the nurse. A floating nurse, a registered nurse is never permitted to perform tasks or render services when he or she lacks the knowledge or skill to be competent in that area. The nurse has to walk a fine line if he or she decides to refuse to float or render care because of that. And the registered nurse may have to find a compromise. So an example to this is have another registered nurse as backup or perform all ventilator cares, but you are still held responsible for the outcome of the patient. So make sure that you're vocal and you request help whenever you need it. You must not do things that are unsafe, even if it's ordered by the physician. You must question orders if necessary and appropriate. If the order does not seem or sound correct, call the physician or go above them if needed. Examples are residents can do and write inappropriate orders that need to be questioned. Being asked to pull the pacer wire as new registered nurse, or any time you are questioning the provider order, you need to check into it further. You must take responsibility for delegated orders within the scope of practice. Are you competent? As the nurse, are you competent in pulling a sheath, for instance? And then in supervisory mode, nurse managers and supervisors can be held liable for inadequate training, failure to periodically evaluate and reevaluate the staff competencies, failure to discipline or terminate unsafe workers, negligence in developing appropriate policies and procedures, and failure to uphold institutional licensing laws and state and federal statutes. And a student can be liable if you do not practice under the instructor's license. Students are held to the standards of the registered nurse and the level of training they've received at all times. Students must never accept an assignment beyond their capabilities. An example is inserting an IV if you haven't been taught that yet, or performing a skill on a patient that you've never completed on a real person. Always do these skills with an instructor or a registered nurse present to make sure that you're doing it correctly, like drawing up insulin, giving IM injections, or administering IV medications.